Australians are free to ignore their bosses when they receive work-related messages, emails and calls after hours. It is the Fair Work Legislation Amendment Closing Loopholes number 2 bill of 2024, section 333M. It's called the Employee's Right to Disconnect. It protects employees from any punishment if they refuse to respond to employees when they're off the clock. You can still reach out in an emergency. Supporters say it keeps work from encroaching on people's lives, a trend they say has got worse since the pandemic. With me is Gabrielle Golding, Senior Lecturer in Law at the University of Adelaide. She joins me now. I was going to say, thank goodness you're not in Adelaide, it'd be middle of the night there, if you were. But no, civilised hour for you. You're in Edinburgh in Scotland now. This is sort of a common sense piece of legislation which has worked elsewhere because it's all requiring about unreasonableness, isn't it? And you can also buy your way out of it.
Well, that's exactly right. So this right as we have it applies to the majority of Australian employees as of today, being the 26th of August. Those that work in small businesses have 1 extra year to wait. So the right will start operating for them next year at the same date. But you're quite right that this right operates insofar as the right to refuse that contact from one's employer is reasonable in the circumstances.
Right. And depends on managerial level. It also depends on whether you were paid extra. You can actually be paid to be bothered, can't you?
Yeah, that's quite right. You can be paid to be bothered. So if you have an on-call allowance as part of your pay that you take home, and you're paid for that time that you're contactable, so that you're paid for the working time, then that's absolutely fine to be contacted in that time.
There's 2 problems with this piece of legislation. The first is enforcement and the second is monitoring. Which employee, other than some bullshit whatever, is going to go to HR and say, I'm getting bothered too much out of work under the Fair Work Legislation Amendment, Closing Loophole Act, etc. Who's going to do that and then expect to have their career progress?
Yeah, look, that's absolutely a fair question, and I think we'll see whether this law has any teeth to it as time progresses on, to see whether employees are indeed utilising it in the way that they are, I guess, inevitably allowed to under the Fair Work Act. And I would say too that there's actually a requirement under the Fair Work Act that conversation must happen at the workplace level first before an employee takes any complaint to the Fair Work Commission.
It's a great idea, but is it realistic? And is it workable? And I understand we're talking about very different levels. If I said to my bosses, don't call me or message me out of work, in my job they would say, Quest, you're paid enough, get on with it. And so I can sort of see it's got to be apples and oranges or apples and pears or whatever.
Yeah, look, I think it's going to be workable for those employees, particularly in knowledge-based work, that are constantly contacted on emails, phone calls and the like. I think those employees in particular will see some benefit from it, and hopefully at least a bit of a shift in workplace culture and societal approach to this. Yeah,
that's it.
and I
no,
think
that's,
that
it's culture, isn't it? It's about it's not about the letter of it. It's about creating a culture where employers, bosses think twice.
That's exactly right. And I think that, from the parliamentary debate that we saw in the lead up to this bill passing into an act, we certainly saw that was the intention that politicians had in passing this through into legislation.
Well, I hope we're not, we are bothering you. It's 9:30 at night in Scotland, but very kind of you for joining us. Grateful. Thank you.